All right, hello everyone. I'm just going to let people gather here. See that people are jumping on the call. Welcome to everyone. We'll just get started in just a minute. Give another minute for people to jump on, but welcome to everyone gathering. Excited to see lots of familiar names joining, as well as some names I don't know. Excited to have you all here. All right, we'll go ahead and get started as people continue to join. So welcome everybody. Thank you so much for joining us for one of our Uni High Alumni Association virtual forums in partnership with the University of Illinois Laboratory High School. I am Philippa Soskin. I'm the president of the Uni Alumni Association, and I'm from the class of 1999. And just to give you a very brief information about the UHAA, as we call ourselves, we were founded really to help bring alumni together, to kind of strengthen our connections and friendships beyond a uni, and especially to kind of give support and help give a voice to the school, and to help the school, to help sustain the school, to really help support the school as much as we can in any way. The main thing we want is membership, because we want ways to bring alumni together. So if you're not a member, please continue joining at uni.alumni.org. It's free to join. We really just want members, and we want to keep these important uni connections strong over time. We host virtual events like this, and we're also hoping to get back to more of our in-person events, of course, as things, hopefully open up more. And of course, the big thing this year, as you all know, is the Century Celebration, which we're so excited to be a part of. And I encourage you all to keep that October 15th weekend available, and consider joining us at the school. It's such a big event for uni, so we hope to see you all there. Very excited to introduce our moderator for today's discussion, my good friend and classmate from 1999, Jeremy Hobson. If you didn't catch Jeremy in his uni years, as in his star turn as Nathan Detroit in Guys and Dolls, or in one of his many other productions and Big Show and other theater productions up in the North Attic, you may have heard him more recently on public radio and variety of capacities, everything from he's former host of Marketplace Morning Report, from host of NPR's Here and Now. You may have heard him recently guest hosting on Left, Right, and Center, or even on one of his many discussions on his own podcast, the Hobcast. So it's my great pleasure to introduce Jeremy, who will introduce the rest of our guests today. Thank you, Jeremy.
Thank you so much, Philippa. And I will not be doing any lines from Guys and Dolls this evening, but thank you everyone for joining. I actually think, looking at the numbers right now, that we are at like a record turnout for one of these events. So that's really wonderful. We actually came up with this idea of focusing on the Supreme Court even before Justice Breyer decided that he was going to retire, before President Biden said that he would name a nominee by the end of this month, which is next week. So it is pretty incredible that we are having this discussion about the Supreme Court right at this moment. And not only do we have the timing down, we also have the guy, the person everyone in the media right now wants to talk to about the Supreme Court, and that would be Richard Lazarus, who I have known for probably 30 years, but who also knows the court better than just about anyone. He's also Uni High class of 1971 and a Max Beaverman Award recipient as well. So we're going to be talking to Richard Lazarus about the court, but also a little bit later, we're going to be joined by two other Uni High alums who are doing very interesting work. And we're going to hear about how the court and the justice system affects the work that they do. So we will bring them in a little bit. We're also going to take some of your questions. So if you have questions, please go into the chat or the Q&A function and put them in there, and then we'll take a look at them very shortly. But first, to Richard Lazarus, who is the Howard and Katherine Aibel Professor of Law at Harvard, where he teaches environmental law, natural resources law, Supreme Court advocacy, and torts. He has represented the US, state and local governments, and environmental groups in the Supreme Court in 40 cases and presented arguments orally in 14 of those cases, author of a number of books, including his most recent one, which I interviewed him about on Here and Now, called The Rule of Five, Making Climate History at the Supreme Court. Richard Lazarus, thank you so much for joining us tonight.
Thanks, Jeremy. What a treat. And I get to see, I see right now, Carla Valance is there, Ellen Wiseman, Ruth Wolf, and of course, Chris Payne. It's a real treat to see people's names.
And did your brother, Billy, make it into the audience as well?
As far as I know, Billy is there. Maybe
Okay.
he is there as well. We had 4 Lazaruses attend Uni High, graduating from 63 to 71.
All right, great, good. So the audience is there, some friendly faces. Let me ask you this first. Was it a surprise to you that Justice Breyer decided that he was going to retire this year?
No, the surprise was he didn't retire a year ago. Everyone thought he was going to retire a year ago. I actually had drafted an op-ed to be published last June as soon as Breyer retired. He didn't. I think I know why he didn't. He didn't because he still thought he could play a useful role on the court. He thought he could build some bridges in a very sort of oppositional bench right now. He's someone who's pragmatic, he's a conciliator, he's someone who can appeal to people and find middle grounds. I think Breyer in good faith thought he could do that. He had some success a year ago doing that, and this term, not at all. It's a storm there. It's not a pleasant place to work, and I think he realized this is not fun. It isn't fun anymore because so many people on the right of the court, very conservative justices, feel pretty untethered. And I think he found there was no middle ground, and so it's time for him to leave.
So what about the pressure, though, that he was facing from people, especially on the left, who were upset after the death of Ruth Bader Ginsburg that she hadn't stepped down when there was a Democratic president and a Democratic Senate to replace her?
Yeah, and they were right to be upset. I can tell you actually a quick brief story involving NPR. After Barack Obama won in November 2008, about a few weeks after that, I was speaking to Nita Totenberg, the NPR Supreme Court reporter, on the phone, actually a native of Urbana, Illinois. And I said very boldly and confidently to Nita Totenberg back then, this is November 2008, I said, Ruth Bader Ginsburg will leave the court in the next 2 years. She'll do that because she knows she has to. She's not going to let happen what happened with Justice Marshall and Justice Brennan. They stayed too long. They got replaced by Republican presidents. And everyone saw what a mistake it was to try to stay too long and throw those dice. She's not going to do it. She knows it's her job to leave in those first few years when there's Democratic Senate. And Totenberg said to me, "You're wrong. She's not going to. When it comes to Ruth Bader Ginsburg, it's about Ruth. And she's not going to leave." I said, "You're wrong. I know it's hard, but I know she'll do it." She said, "No, she won't." I talked to Totenberg about this about a month ago. I said, "I think you were right." Breyer saw that too, but he wasn't under the same pressure a year ago because we had a new president and we had a 50-50 Senate, so somewhat control. And I think he thought he could last a little longer. I think it was a mistake because the Senate is so close. All it takes is the death of one Democratic senator or Republican governor,
right,
to switch it. But I also think the pressure backfired. And I kept trying to tell people, shut up. Stop telling Breyer to leave. Stop telling him he's got to do it politically. Because Breyer felt to him, it was very important not to make the court look political. So every time people, for their own egos or to raise money for organizations, said, Breyer must leave, it made it less likely for him to leave. Now, I don't think it should have made it less likely, but I think it did. And people calmed down this year. I think that's part of it. And the other part was, it just wasn't fun anymore.
It's interesting to think about also whether what the White House, if anything, did to try to get him to do this now. I remember reading about when Justice Anthony Kennedy stepped down, and then Trump nominated one of his former clerks, Brett Kavanaugh, that maybe there was some, I don't know whether there was some actual agreement or they had talked about it. And if I do this now, will you put this person in? Do you think the White House pressured Breyer at all?
No, but I think you're absolutely right. What happened with Kennedy and Trump? Trump really did court. One of Kennedy's sons is a close friend of one of the Trump sons. So there really was some courtship going on, appealing to Kennedy's ego, and I think a former clerk was part of the idea there as well. So I think that's accurate. It was Gorsuch, though, of course, who I'm sorry. Well, you're right. It was Kavanaugh who replaced. But I think Breyer just doesn't work that way, and Biden knew that, and Biden understood. Biden's a savvy politician from the Senate. I think Biden figured out that would backfire. Remember, of course, Bill Clinton tried that with Ruth Bader Ginsburg. He invited her to lunch. He sort of was planning the idea. It went nowhere. I'm sorry, Obama did that with Ginsburg.
Obama did that with Ginsburg. I was going to say Ruth Bader Ginsburg was nominated by Clinton.
Yeah. Obama did that with Ginsburg. He invited her to lunch at the White House. And the unstated message was, what about? It didn't work. I think Biden was smart. He realized it's not going to work. Ron Klain, his chief of staff, is someone who, Breyer's going to know well as well. And so I think there were enough Breyer connections. I think he felt good about the president and the White House. I think it was more carrots that way than anything else.
So we're expected to find out who President Biden will nominate to replace Breyer within the next few days. He has said that he will name a Black woman. What do you think the significance of that will be, to have a Black woman on the court? There is already a Black man on the court, Clarence Thomas, who was nominated by the first President Bush and is very conservative in his decisions.
Yeah, I think it'll be very significant symbolically for the court. Thurgood Marshall was the first African American on the court. I argued before him a bunch of times in the 80s. It was quite clear he was an historic figure. And everyone back then said, 100 years from now, no one can remember any of the justices on the court but Thurgood Marshall. I think the same is true about Sandra Day O'Connor. She was an historic figure. They were also great justices on the court. I think this is a big moment historically. It's got symbolic significance, partly because the people he's considering and the person I think he's going to choose is really qualified. And everyone's going to see that. They're going to see those qualifications. They're going to see that person. It's going to make a major statement about law and justice and judges when people get a close look at his nominee. So I think it was a bold statement and a good one.
So the three names that people are talking about right now are Ketanji Brown Jackson, who's on the U.S. Court of Appeals for D.C., Leandra Kruger, who's on the California Supreme Court, and Michelle Childs, who is on the U.S. District Court in South Carolina, and is the one who has some support from very important politicians like James Clyburn, the Democrat, who very much helped Biden get the nomination with his endorsement before the South Carolina primary. Do you think it's going to be one of those three? And it sounds like you might even think it's going to be a particular one of those three.
I do think it's going to be a particular one. I could be wrong. I think it will be one of those three. It surprised me a great deal if it's not one of those three. I think he's forecast that deliberately. You float that information out, and then that helps find out if there's any dirt anywhere, which is one thing you're trying to find out. So I think it's be one of the three. They're, I think, all very qualified. Certainly, Judge Childs, one of her main things going for it is Clyburn. I mean, he's an amazing member of Congress, and Biden really does owe the White House to Clyburn. He rescued him in the South Carolina Democratic primary there. I still don't think it's going to be Child. I don't think it helps Child that Lindsey Graham says you should go for Child. If I were Biden, anyone that Lindsey Graham supports, I would actually not pick for that reason, because I wouldn't want to look like I was pandering to him, and I wouldn't trust him anyway. He's kind of snake oil like. He'll turn on you in a second. All three are qualified. The person I think is most likely to get it for a very practical reason is Judge Jackson from the DC circuit. And I don't say that because she's a Harvard Law School grad. I say that because of the three, they all have great qualifications. She certainly does too. Her paper credentials are as good as anyone on the court. But it's because of the three, she's the only one who's been recently confirmed by a highly divided partisan Senate. That is not true for Kruger, who's on the California Supreme Court. It's not true for Child, who's on the district court in South Carolina who's been nominated for these seats but not confirmed. And she's been through that crucible and recently. And what that means is we've already seen what can come out. If Republicans have every dagger out, every research team trying to find everything they can, there are no surprises with Jackson. And the one thing we've learned, and Brett Kavanaugh and others have learned, is when you get nominated to the court, it's a whole nother level of scrutiny. And you never know what information is going to come out throughout your entire life or the life of a loved one or a family member. With Jackson, she was just confirmed basically last summer, last June. Everything's out. That's the safest bet. She's the safest bet, I think, of the three.
Well, so when you look back at previous nominees, like years and decades ago, they were getting almost unanimous approval by members of the Senate in both parties. And in recent decades, it has gotten more and more partisan to the point where with, I believe, Amy Coney Barrett didn't get a single Democratic vote when she got through. She just barely got through. Do you think we'll ever, is there any going back to a point where senators of both parties say, yeah, okay, this person's qualified, let's put him in?
Yeah, I sure hope so, but it's hard to see the kind of political polarization that we have in this country right now going away anytime soon. You go back a few decades, you go back many decades, they didn't even have hearings at all. You go back a few decades, and the fact is, it was sort of a fait accompli. You gave the president deference. Justice Scalia, I think it was 98-0. And people knew how conservative he was. Ruth Bader Ginsburg was very easy as well. I mean, if you find a date when it changed, but not completely, of course, the Robert Bork nomination, where the Republicans felt like the Democrats had played a new level of hardball and stopping Bork. And after that, the Republicans have been much more on edge about it. They've let a couple pass through. Breyer was actually nominated by Clinton because he was considered to be the conservative, moderate one. Clinton blinked. He wanted to put on the court Bruce Babbitt, a big liberal. And the Republicans said, if you do Babbitt, we're going to filibuster. And they said, but if you do Breyer, it's smooth sailing. Because they view Breyer as friendly to business at the time. If you go back to Roberts, right, 2005, the vote, 78-22 was their vote on Roberts. But basically ever since, scorched earth by both sides.
Well, do you think that the justices who get by just barely or have a really partisan fight when they're confirmed have a chip on their shoulder forever after that when it comes to one party that tried to stop them?
The answer should be no, but the answer I think is yes. I mean, my feeling is you get on the court, you should be a Supreme Court justice, and a Supreme Court justice to everyone, including those who voted against you and criticized you. But I just looks empirically looking at them, I think they have a chip on their shoulder. Clarence Thomas clearly has a chip on his shoulder. I mean, he was really treated in a way which I'm sure from his perspective was horrific. I mean, he called it a high-tech lynching at the time. And I think he harbors a grudge against the party, against the Senate. I think Alito does as well. Remember, Alito's wife famously cried during the hearing because she was so upset about hearing what they were saying about her husband at the time. Kavanaugh, right, famously said, what goes around comes around, right? That was sort of an expressed threat about what would happen given the treatment he was getting. I would hope that they would dial it back, but I'm not seeing as much as I would have hoped in that area.
I want to just ask you about this term because, yes, this year on the Supreme Court is going to be remembered for whoever replaces Stephen Breyer and for the end of his career, but also there are some big cases, and one of them is about abortion. It's a challenge to the restrictive abortion law enacted by Mississippi in 2018, which bans most abortions after 15 weeks. And the question is the Supreme Court going to roll back some of the constitutional protections established in Roe v. Wade in 1973, by the way, 2 years after you graduated from Uni High? How significant is this case? And do you think that they are going to, go back and revisit something that the court has already decided and make a different decision?
I think they're likely to do that. I wasn't sure that would be the case until I listened to the oral argument in the case. As everyone knows, we have an outsized conservative majority in the court, 6 justices on the conservative side of the bench. And that's a big difference from the very sharply divided court of more like a 5-4 we had for 20 years. That closeness tend to have a sort of braking effect on how far anyone would go to try to keep that crucial 5th vote. Even when John Roberts, before Barrett joined the court and replaced Ginsburg, it was 5-4. He's a very conservative guy, but he had some sort of modicum of modesty and institutional concerns about the court's reputation. He served as a brake, but as soon as Barrett replaced Ginsburg, there was no brake anymore. And then the big question this term, really for the first time, the full term with that new sort of 6-justice conservative majority was, would they be sort of conservative in the sense of, incremental and moderate in revisiting cases, or would they be muscular and aggressive? Every single sign we have, every single sign without exception, is that they are going to be muscular, aggressive, and impatient. Impatient to make change. And you see that in their decision not to really stop for the longest time the Texas abortion law. You saw in the oral argument in the case, when Roberts tries to come up with some sort of moderate position, and he's not a moderate, but he's more moderate than the others. And you hear the 5 justices basically saying, going right at Roe. Not even sort of an invitation to sort of a disingenuous, maybe, reinterpretation of Roe, but it looks like they're headed more for an outright reversal to something very close to it. But it's not just Roe, Jeremy. We see that in case after case this term. They seem impatient to make radical, quick change, as fast as possible. The voting rights case in Alabama just a couple of weeks ago, there too, Roberts kind of says, slow down, slow down. It doesn't seem to be happening. It could be quite a big June this year.
What are the? I mean, there's a gun case as well.
Yeah, there's a Second Amendment gun rights case involving concealed weapons this term. There's the abortion case this term, which is receiving outsized attention, and then a case being argued this coming Monday, a case sort of in my wheelhouse called West Virginia University EPA, and that's the fate of the EPA's authority to regulate greenhouse gases for power plants under the Clean Air Act. And there's sort of case after case that they take it. Next term, they've already got the affirmative action case from Harvard and North Carolina, and they've got a big Clean Water Act case involving the geographic scope of the act. What's interesting about many of these cases, Jeremy, is a lot of them lack the traditional indicia for Supreme Court review. They were cases where normally the court wouldn't have taken this case. They would have waited several years, let the lower courts percolate, let them come out with their own views, see if there's a conflict in the circuits. They haven't done that. In case after case, they see a big issue and they grab for it. The gay rights case they just took out of Colorado about whether or not a web designer who objects to gay marriage, whether they have to sort of do that. Again, that particular case, it was not at all clear that was ready ripe for Supreme Court review. Shoom, went out and grabbed it. So this is not a court which is incremental.
But so you mentioned Justice Roberts. I know that he is very concerned about the court losing its credibility with the public. So how is he feeling? I mean, you know him very well. You guys were Harvard Law School roommates, but how does he feel about the credibility of the court?
Yeah, I can tell you what I think he feels. I can't tell you what he feels because he'll have to speak for himself, which of course he was never going to do. I mean, this has got, his job has gotten really hard. When it was a 5-4 court and he was the chief and he was the controlling vote in the case, he could do just that. He could temper how far and how quickly they went. They didn't take Second Amendment cases for a long time. They weren't taking the abortion cases. He was sort of blocking them from doing that kind of high profile stuff. But when There are 5 justices to his right, and it's a rule of 5 when it comes to the United States Supreme Court, and that is what 5 justices say governs. He can no longer control the cases they take, or can he control the outcome the way he could before? So he's got a much harder job. And justices like Gorsuch, sort of the young rebels in the group, they bucket authority, very non-deferential to the chief. When Justice Scalia was there, he was an institutional, he was very conservative, institutional player. He'd say to the chief, what can I do for you? How can we make this work? This new group, they are without those kinds of bounds, especially Alito, Gorsuch, and Thomas. What we're going to find out this term, Jeremy, is to what extent is Kavanaugh and our Barrett willing to play with the chief to try to pull back. That's what we've been waiting for this term. So far, not a lot of evidence that they're going to do that. A little bit, right? They upheld one of the COVID cases, the authority of HHS. And that, Kavanaugh joined the chief, Sotomayor, Breyer, and Kagan to uphold that particular COVID case. So we see some breaks. I've seen in some environmental cases, but at least so far in the oral arguments, I'm not hearing what I thought I might be hearing.
Okay, so one of the things that Democrats, especially heading into this last election, were hoping to see when Biden got control of the Senate with the 50-50 split, was that he would expand the Supreme Court, make it, which is perfectly within his, he would need some help in the Congress, but it's within his power to do it. It's been done before. Vicky Patterson Wagner asked this question as well. By the way, if people want to ask questions, go into the Q&A and put them in there, but I will ask Vicky's question. Why, she says, why does the court have to be so political? I'm sorry, we're going to get to that in a second. Rosanna Francescato says, do you think that expanding the number of justices on the Supreme Court can help address the politicization we've been seeing?
Yeah. All right. I think the short answer is no, because all that's going to happen is if we expand it, it's going to become this back and forth and back and forth and back and forth. Every time a party is in control of Congress and the White House, they're going to expand the court. And we saw that actually in the 19th century. The court size fluctuated. In other countries, they have Supreme Courts of 30, 40, 50, 60 judges. It becomes sort of like a mini legislature, and the underlying premise is they are supposed to vote with their party. So in theory, I think it's a terrible idea. But here's the problem I have with my theory. We're in a terrible shape right now. The court really has been, I think not through its own movement, but by presidents of the United States and by the Senate, they really have now risked of becoming far more politicized than they have been in recent decades. So we do have a court which has a problem, and we do need a fix. And so, I may think that's a bad idea, we're already in a bad situation. Term limits, I think, is a bad idea, but it may be better than what we've got, because once we have presidents who appoint people at age as young as possible, we have justices who stay as long as possible and abuse the whole idea of life tenure by seeing how long they can last and presidents how long their legacy can stay. We may have to move to it. But of course, the practical problem is this, and that is the votes aren't there. There are no votes in Congress right now to expand the size of the court.
Well, what about the term limits? Why do you think that's a bad idea?
No, well, term limits, it's an idea which isn't even close to right. It would require amendment to the Constitution. So good luck with that. I think it's a bad idea, but I'm saying I think it's a bad idea, but it may be the right way to solve a bad situation we have right now. I like the idea of justices coming and going without being able to predict it. I know, for instance, if I'm a Supreme Court litigator and I know that a justice is about to go or just about to come, I know their exact timing, I'm going to game the system. I'm not going to bring cases at a certain time. I'm going to bring cases at other times. I'm going to game everything because I know exactly when things are going to change. I think it's better to have that uncertainty. I think justices often are very, very good. You know, a lot of great justices have been terrific long after 15 years when they're not trying to get their next job or make a big name for themselves afterwards. So I think I think the life tenure system is better, but I also think it's broken right now. So if we could do term limits, if we could actually get a constitutional amendment, I think it might be the right thing. I don't like it, but I think it might be the right thing. But as a practical matter, you're not going to amend the Constitution right now.
Adrian Albrecht says, isn't expanding the court better than the court losing all credibility?
Well, I think if you expand the court, I think it's going to continue to lose all credibility because it's going to, I mean, I think that might be a short-term solution. The people who add justices will think, well, our side's winning, so that's credible. I mean, people often think if their side wins, the court's credible. That's the institutional integrity. If we lose, then they're all politicians. I mean, everyone tends to do that. If you can increase the size of the court, and you of course can legally do it by votes of Congress. If you do, then it's going to keep increasing. It's going to be tit for tat, tit for tat, tit for tat. I don't think at the end of that tit for tat, we'll have a Supreme Court which has anything close to the institutional integrity that it has historically. And that's why Breyer has opposed it. Ruth Bader Ginsburg opposed it. I don't think there's been a justice who's ever thought it was a good idea because they know the damage it would do. Short-term satisfaction, long-term, I think it could lead to this court, which is what other countries have. These courts, which are basically mini legislatures with 30, 40, or 50 people on the court.
Before we bring in our other guests, I want to ask you, because you have argued before the court, we said 40 times, and oral arguments 14 times. What is that? What is that like?
It's really fun. It's really fun. I happy to say I won my last case in 2017, and actually in preparing for the argument, I contacted one of my Uni High classmates to talk about how to answer a certain question before the court, and we worked it into the oral argument as well. It's a thrill. You're up there for, it's an hour-long argument. You get asked about 50 to 75 questions in 30 minutes. It's just rat-tat-tat. They're really smart.
Who asked the best questions?
Well, Scalia was always all over me. I mean, all over me, nonstop. I think I hardly ever argued a case position like, although he did vote for me in one environmental case when I represented the Environmental Defense Fund. I did get his vote, and he wrote the opinion for us. Scalia was the toughest because he just derailed you. He mocked, he laughed, he interrupted you. The hardest questions I often thought were Justice Stevens. He was so damn smart. And Stevens would basically go like this, Mr. Lazarus, may I ask you a question? He was very polite. He'd always ask permission to ask you a question, which is like ridiculous. And then he'd ask you a question, unlike the others, that was like 3 sentences long, very short. And in it was just a buried something that if you answered that question wrong, you might see a little grin, he had you. So, I mean, he tried to figure out a way to get you to reveal a weakness in your case, which then he would run with. So he'd be really careful with Justice Stevens' questions. Justice Breyer was an impossible person to answer questions for. He'd ask a question. I had it for administrative law in law school. He's a much better justice than he was an administrative law teacher, unbelievably boring. But as a justice, he'd ask a question which is like 8 pages long. I mean, you'd be sitting there, he'd be talking and talking and talking and talking and talking and talking. You're trying to stay awake. And then finally at the end, he'd go, well, what do you think?
Like, by the way, I've had co-hosts like that, believe me.
And you had to figure out, I guess there's a question somewhere in the last, 8 minutes. He would eat up your time that way. But I loved answering Justice O'Connor's questions. She always asked the first question. She always asked the single hardest question for your side. You knew it was coming. She'd look at you. You get the question, you prepared for it, and you nail it as well as you could. Marshall was, when Marshall asked you a question, you just felt how privileged you were to be in a conversation with Thurgood Marshall.
Let me just finally ask you before we bring in our other guests. I assume there was not a pre-law class at uni when you were there. So was there anything about your time at uni that led you into the career that you are in?
I don't think so, but I decided maybe for this purposes, I'm gonna put up a picture of Ella Leffert. So Ella Leffert was my social studies teacher at Uni High, and she was a terror. And she was certainly someone who taught us rigor and careful analysis. I mean, when I left uni, I was thinking of going to law school. I don't think there was any particular teacher that inspired it. But I certainly often thought as a teacher now, and as someone who analyzes things really closely and precisely, like you have to do for a Supreme Court argument, I often think back of Ella Leffert with her three circles: social, political, economic, and really just a terrific teacher. I did well in her class for only one reason. Her favorite student of all time was my oldest sister, Barbie Lazarus. And Ella Leffert would sometimes in class call me Barbie. She was so old, she kind of forgot I wasn't Richie Lazarus, I was Barbie Lazarus. Whenever she made that mistake, I never corrected her, because I thought if she looks at me and sees Barbie Lazarus, that's my best shot of getting a good grade in her class.
And by the way, there is a fund for those of you making donations to Uni High. There's a Barbara Lazarus Memorial Fund that you can choose when you make your donation, as I do every year. So please check that out. Let me have you, Richard Lazarus, stand by. It's hard for me not to call you Richie because that's how I know you.
Well,
and by the way, everybody else here does too that knows you, right?
You know, a lot of people do, and sometimes it happens in my law school classes. I have a guest come on, and they refer to me as Richie Lazarus. My students all titter when that happens, and I stop. I glare and look at them. That's Professor Richie to you.
Okay, good. All right, so stand by. Let me bring in Sean Morales Doyle, who is the acting director of the Voting Rights Program at the Brennan Center for Justice. He is in New York. And Sean, you are class of?
2000.
2000, 1 year after me. Sean, welcome. Thank you so much for being here. And
Thanks for having me.
Bianca Zaharescu is also with us in the car in Mississippi. She's co-founder and chief financial officer at the Spring Initiative in Clarksdale, Mississippi. Bianca, are you safely pulled over to the side of the road? Maybe not yet. Okay, not yet. But when she gets there, we'll bring her back in. Let me go to you, Sean.
I am now.
Oh, good. Oh, good. Bianca's there.
Can you hear me though? Because
Yeah,
I am in the middle of the country.
You sound perfect. You've got good 5G awesome. Service there. So Sean, let me start with you. How does the Supreme Court impact your world and what you do?
Lately, in mostly not so great ways. So I work primarily on voting rights, obviously, and this court has not been kind to the work that I do. Twice in the last, I guess it's 9 years now, the Supreme Court has dealt a major blow to the Voting Rights Act of 1965, which is, you know, the crown jewel of the civil rights movement and kind of the foundation for much of the work that we do as lawyers in the voting rights space. First in 2013, the Shelby County v. Holder decision, which was authored, the opinion was authored by Justice Roberts. The court basically put the pre-clearance provisions of the Voting Rights Act on ice. So the provision of the law was perhaps its most powerful remedy for race discrimination in voting. It required jurisdictions with a history of race discrimination in voting to run their changes to their election laws by the Department of Justice before they could go into effect to make sure they weren't discriminatory. The court said that the formula for deciding which parts of the country would be subject to pre-clearance didn't have proper support when Congress passed it. It was outdated, and so they struck down the formula, which means that now there's no pre-clearance. And then just last year in 2021 in July, the court again did some damage to the Voting Rights Act, this time a different part, Section 2, which is the part that lawyers like me use to sue to challenge racially discriminatory voting laws. And the court basically created a new way of applying Section 2 that makes it more difficult to bring those kinds of challenges. But then apart from the big sort of blockbuster decisions in 2013 and in 2021, the court has, in what Justice Kagan referred to very recently in decision that Professor Lazarus just mentioned, referred to as the shadow docket, in without ever issuing an opinion, without deciding a case, the court makes decisions that have made it harder to use the courts to protect voting rights recently, by issuing stays of decisions protecting voting rights or other things like that. And so they don't actually hear the full case. They don't issue a full opinion. Sometimes they issue an order without explaining themselves at all. But in so doing, they, have, it sort of has these ripple effects down through the courts, and it makes it harder to actually protect voting rights through the courts. So lately, the Supreme Court is a place where I hope my cases don't end up.
Let me, before I go on with you, let me ask you, Richard Lazarus, to just talk a little bit about the issue that Sean brought up first, which is the voting rights. Because there's a question that also came in from Carla Valance, who says, "What about Roberts' gutting of the Voting Rights Act?"
Yeah, no, actually, I was just like Supreme Court protocols. You never refer to the Chief Justice as Justice. You always do Chief Justice. It's even in all the guidance they send you. So I always go like that when people say Justice instead of Chief Justice. No, I mean, the Chief is very conservative. He's moderate in this group of 6, which tells you things. But he's very conservative. I mean, I can't say I support either of those votes. I don't think that I get a vote, unfortunately. I think both of them are very damaging opinions. We are, as Jeremy knows, we're very close friends. We have been. I don't tend to pick my friends based upon whether we agree about the different parts of the Constitution. I don't think he's ever voted with me in any case I've argued before the court. And I think the Voting Rights Act case, especially the last one, I thought the most recent one was even more devastating than Shelby County in certain ways.
If I can just, clearly I've not argued before the Supreme Court, so it's probably me who said Justice Roberts.
Oh, so did Jeremy.
Professor Lazarus earlier made a comment about how recently in a voting rights case from just a couple of weeks ago, this is the one I mentioned as well, that it's Justice Roberts who seems to be trying to pull the conservative side of the court from going off the deep end with regard to this thing called the Purcell principle. But the Shelby County decision was authored by Justice Roberts, and I actually had a conversation with a congressional staffer who worked in the Senate in 1982 when the Voting Rights Act was amended in 1982, leading up to the case last year, which was about the 1982 amendments to the Voting Rights Act. And he said, our enemy in the Senate on the Democratic side in trying to make the amendments in 1982, it wasn't Senator Dole, it wasn't, these Republicans who were fighting us publicly. It was a young lawyer in the Office of Legal Counsel, and his name was John Roberts. This is a many decades long sort of issue for Chief Justice Roberts, and yet now, just a couple of weeks ago, we see that he is actually, trying to keep the conservative side of the court from going even further. And the difference between the 2013 opinion, which he authored, and the 2021 opinion, which was authored by Justice Alito, it's stark. The place where the court seems to be heading on voting rights seems to be even outside the reach of this justice, the Chief Justice, who has been, sort of fighting against the Voting Rights Act for a very long time.
I mean, absolutely right. I mean, it shows you how far the court has gone. I mean, the Roberts view on Voting Rights Act is very much what he was saying in the early 80s. He at that time was actually in the White House counsel's office and the Attorney General.
You're right. Apologies. That's okay.
All right. It's meaningless to anyone else in the world in terms of distinctions. But that's what he's always thought. But that's a traditional sort of Republican view that way. I don't endorse it. He's held steady on it, unfortunately, like affirmative action. I don't think he sees the nuance there as well. But it does underscore how far right those other justices are. That even in this most recent case, the Obama case, he's voting with the liberals to uphold a lower court decision, which a lower court decision, by the way, which I'm sure he didn't agree with. I think on the merits, he probably would agree ab initio with his conservative colleagues, but he believes in incrementalism. He believes in the little bit stare decisis, so he wasn't willing to do what they did. But when it comes to it, he's a very conservative guy. It's just really extraordinary that he is considered he's a moderate
in this court. Sean, on the issue of voting rights, the place where people have been looking recently is not so much the court, but Congress and President Biden, who it doesn't sound like that's going to go anywhere right now. Who knows? Maybe they'll come up with some sort of new compromise. But what about the fact that the federal voting rights legislation that was talked about doesn't look like it's going to happen? What does that mean from your perspective?
It means, despite everything I just said, we're probably going to be spending a lot more time in the courts. So Congress was considering these two pieces of legislation that were combined into one, which was known as the Freedom to Vote John R. Lewis Act. The John R. Lewis Voting Rights Advancement Act, half of it was basically aimed at restoring the Voting Rights Act of 1965 to its former glory, undoing the harm done by those two Supreme Court decisions that I mentioned. And the Freedom to Vote Act was aimed at sort of setting a floor for federal elections across the country as to what elections had to look like, how much early voting needed to be provided, what sort of access to mail voting needed to be offered, that sort of thing. It enjoyed both of those bills, and the combined bill enjoyed the support of all 50 Democratic senators. And in fact, the John R. Lewis Voting Rights Advancement Act also was co-sponsored by Senator Murkowski, a Republican, but they essentially died on the floor because of the filibuster. And as you said, maybe we're going to keep fighting for them. We hope that something will change, but as of right now, they're not going anywhere. And so that means that we're stuck with the Voting Rights Act that has been, I shouldn't say stuck with, it's still the Voting Rights Act of 1965. It's an amazing piece of legislation, but it's been weakened by the Supreme Court. We have fewer tools available to us than we had before. And as a result of something, a few days ago, a judge in Arkansas followed the lead of two of the Supreme Court justices from the conservative side, Gorsuch and Thomas, who wrote a concurrence in that case from last July, where they went even further than the rest of the court and said, maybe you can't even bring a lawsuit under Section 2 of the Voting Rights Act. And a judge in Arkansas just took them up on that argument the other day. I'm litigating a case in Texas right now where Texas is making that same argument. Georgia's made that same argument. So a couple of the justices have sort of signaled to the lower courts that they could take this even further. And that's the world that we're in. But unfortunately, without action by Congress, that's what we have to work with. So as I said, we're suing Texas right now over an incredibly restrictive voting law that they passed last year. And we've had some initial success, had a preliminary injunction entered a couple weeks ago. Unfortunately, the Fifth Circuit stayed it last week, and we'll be arguing that case in a couple months. But that, unfortunately, the federal courts not being the friendliest of forums for us right now, that's where we are.
That's
so
where
Jeremy, if I can underscore one thing Sean said, because it's really important to understand. Historically, in the past several decades, when the court has sort of gone a little far, Congress has come back and passed legislation. We've had several times, we had Civil Rights Restoration Acts, where a court would go a little too far one way, particularly to the right, and Congress would pretty quickly, they'd pass a law to fix it. That's the way things should happen. It's an iterative process. But the problem we have with the court right now is that we have an absolutely broken Congress. They don't pass anything anymore. And that's because, as we all know, it's the outsized use of the filibuster. They filibuster absolutely everything. Even when the votes are there, you can't get anything passed. There could be a majority, a good majority, you can't get anything passed anymore. And that really exacerbates the problem we have with the court.
So one of the things that I discovered as a journalist covering the country and the world is that even when Washington is at a standstill, there's a lot that happens in this country. And so that is why I want to now go to Mississippi and Bianca Zaharescu, who is co-founder and chief financial officer at the Spring Initiative in Clarksdale. Bianca, first of all, just briefly tell us what the Spring Initiative is.
Yeah, hi. So Spring Initiative, we are a nonprofit, an educational nonprofit. we work long-term and in a really holistic way with basically those young people who even within the Mississippi Delta are facing some of the highest challenges and kind of some of the greatest systemic and personal obstacles to success. And so we basically, it's like very wraparound. We work with their families, we work with therapists and teachers to really support them to actually beat the odds that are very highly stacked against them and be able to create the lives that they desire and deserve for themselves. So that's kind of in a nutshell. So it's an after school program, but it is much more intensive than that. And that's like the work that we do, very, very individual focused. And currently we have 80 long-term students and we're adding 16 more next month. So.
And you're in Clarksdale in part because of something that a number of Uni High students experience, yes. Right? Which is that Mr. Sutton took students down to do Habitat for Humanity in Clarksdale, Mississippi.
Yes. Yeah. So like the connection initially was a bit random in that sense. Like I went on a Habitat trip and then kind of stayed, went to the University of Illinois, got a double major in African-American studies and history. So very much not some of the realms that other people's expertise is in, but the location is not really random in the sense that it really it's, the tourism office here has bragged before about how 100 years ago, Coahoma County had the highest rate of millionaires per capita, which if you break that down, right, that is directly related to everything, to the cotton, to the slave, industry, all of that. So it's a place that is very specific in the United States in terms of kind of how racialized the injustice has been historically and still to this present day. And yeah, so that's kind of the reason for that location is it was partly this Habitat trip, but the reason for that trip being there is because it really is it's a particular place in this country.
So as you listen to the conversation we've been having about the court, how does the court, or let me more broadly say the justice system, impact the work that you do and the people that you work with?
Yeah, so that is a huge question, and the impact is unfortunately often can be kind of debilitating in a lot of cases. So we work with young people, like I kind of was saying, and for the young people in our program that we're working with, growing up here in the Delta, even the places you're supposed to be, right? School is supposed to be the place you're learning. Already, corporal punishment is the primary way that basically authority interacts with you already from school. So kindergarteners, they get paddled, they get hit for throwing a pencil. If you're in high school, you can get hit, again, paddled for being late to class. I don't think we have a single student in our program who has not received corporal punishment. So that's that's not supposed to be the justice system, right? That's supposed to be the school system, the education system that already kind of acts in such a punitive way that it almost, it can feel like already kind of the pathway to prison. But then we literally have students. We have a 13-year-old who was caught up in a situation with some older students, ended up in the adult prison or in the adult jail, and they were going to keep him there for months until Spring kind of advocated on his behalf. So the level at which people kind of are controlled sort of in so many different aspects of their lives and sort of end up a lot of times slipping into the justice system in ways that are not very justice centered. It's pretty ubiquitous, unfortunately, for a lot of the people who are working.
I imagine that without help of someone like you and your group, it's very difficult for these people to navigate the justice system and to do things in a way that, somebody who has a lot of money and fancy lawyers would be able to do.
Right. I think it is. I think that in a lot of cases, Spring is called in as kind of a third party by parents, by students, to basically be able to be somewhat of an advocate that can more so be taken seriously by the court, literally to speak in front of that judge. In that case, this 13-year-old was being tried as an adult. He was part of they robbed a Domino's, it was an armed robbery. The other people were 16, 16, and 19. And even though he was 13, he was being tried as an adult. And it took kind of somebody that would be able to both like kind of have the confidence to speak and sort of challenge in some ways the judge, the court, but also kind of have the ability to in some ways be taken seriously by that court. And we advocated, and we were successful in basically that he got released and then has kind of a more probation type of program instead of they wanted him there for 4 months in the adult jail until his court date. So I think it is like for so many people, nonviolent offenses or just that first offense, they can really turn into situations where they get entirely lost and kind of trapped in a system that is, it is very much not focused on any type of, helping them rehabilitate in any way.
Richard Lazarus, let me bring you back in because I want to ask you, as you listen to both Sean and Bianca talk about people who are disadvantaged and who do not have a positive interaction with the judicial system, is there any glimmer of hope that you would give them about, can things get better, or are we on a path where this country is going to just become more unfair to people who, start out in a disadvantaged position?
Well, as Sean said, I certainly wouldn't look to the United States Supreme Court right now. I mean, your real job is to keep everything you can away from the Supreme Court. I mean, I do think, President Biden has put a lot of new judges on the federal bench, a sort of record number of judges in his first year. It's a very, very diverse group. He's got former public defenders. He got former community organizers. He has former, legal aid. I mean, it's a really good group, and it's a group which has a lot more experience with communities. So I think in the lower courts, the lower federal courts, we've had an injection of people who are being much more sympathetic. And remember, the Supreme Court only hears 60 to 70 cases a year. And there's a lot more that happens that is way, way, way under the radar screen. That's where most people meet justice. So I do think there's reason for hope in terms of the lower courts. It's a practical matter, as Bianca knows too. It's actually not the federal courts. It's really the state courts where most of this, where the rubber hits the road. And so it's a question of state by state. And we have a real divide in this country now between red states and blue states. And I think it's gotten worse and more exaggerated. And I think there's going to be more justice in some places than in others. And I'm not sure that's going to be solved anytime soon.
Sean, if you could snap your fingers and change one thing about the justice system, what would it be?
Well, I guess I would say I put a comment here in the side responding to something that actually my former boss was nominated by President Biden to be on the Second Circuit recently. And I think that is a big piece of it. I think that the people who are hearing these cases and the people who are responsible for doing justice need to be more reflective of our country than they are right now. Or even of the legal profession for that matter, which is a pretty elite and tiny group of people in our country. And the courts aren't really, and haven't been for some time, reflective of either of those things. And I think it would help a lot to have people who came from our communities and cared about the things that all of us care about serving on the courts. And maybe we're heading somewhat more in that direction. So I would change a lot of things, but I'll start with that one because it was just mentioned.
Bianca, what about you? If you could snap your fingers and change one thing, what would it be?
Yes, I wish I could. I think the one thing I've thought about, like, what would one thing be? Right now, our state, we pay a little over $5,000 per student to get educated. K through 12, and we pay over $18,000 for each person who is incarcerated. But that $18,000 is distributed towards nothing of value to anyone. It is they basically are being dehumanized with nothing that's rehabilitatory at all. Private prisons, etc. So I think that's what I would change. I would change that, like, if you're really going to spend that much money, actually use it to, like, bring therapists, bring, like, people who can actually, provide opportunities like job training, things like that for people who have gotten into the system. Or, maybe even that spending out a little bit, like maybe you can cut that one down a little and, raise up the education one to begin with, which you'll probably see a lot less people even interacting with the justice system.
Jeremy, if I've never been able to snap my fingers, but the historic moment we had was Donald Trump winning the White House in 2016. If Hillary Clinton won the White House in 2016, we would immediately have had the first working progressive majority on the Supreme Court in 50 years, with Merrick Garland going on, in 50 years. And then she would have replaced other people. We would have had an outsized progressive number of justices. That was an historic election. And we wouldn't be talking on the Democratic side right now about term limits or this or that if that election had gone differently. That was a massive loss in 2016. If I could snap my fingers, I would change that election and Donald Trump would disappear. I would never have to hear his name ever again.
Okay, well, there's a note to end on, but actually, I will say that Ella Leffert is getting a lot of love tonight in the chat, and I will leave you with David Rosen, who says she was my favorite teacher and convinced me to go to the London School of Economics for my undergraduate. The best. There's Ella Leffert. I want to say before I just thank our guests that we spent this evening talking about the Supreme Court, which is an institution who's been around for hundreds of years. Uni High now in its second century. And I want you to stay tuned for more virtual events like this one during our year of celebration, which leads up to the big Uni High Central celebration in Champaign-Urbana on October 15th. You should go and think about your travel plans, because I just looked and my favorite hotel is already booked because it's happening the weekend of homecoming or something like that. So go make your travel plans now. Don't wait, and support Uni High so it can be here for at least another 100 more years. So you can have brilliant alums like the ones we've been talking to tonight. And you can do that by going to go.illinois.edu/supportuni100. I want to thank Sean Morales Doyle, Bianca Zaharescu, and Richard Lazarus, and Philippa Soskin, our president of the Alumni Association, and everyone who came tonight. And please come to the next one. And thank you so much for a great evening.
Thank you so much.
Thanks for having us.
Thanks, Jeremy. Always a treat.
Thank you so much, everyone, for coming, and to all the panelists and to Jeremy. Thanks, everybody.